This is Lecture 2, the macroeconomics of the patent system and some policy alternatives. The agenda for this lecture is to go over the economics of patent law, discuss some current debates about patent law and economics, and then evaluate and discuss various policy alternatives to the patent system. Patent economics. So we went over this a little bit in class 2, but let's revisit. All right, the basic idea here is that in a competitive market, which we're showing here in this graph, the price is on the y-axis to the left, the quantity is on the x-axis to the right, more quantity to the right, more price higher. There's a demand curve that's the sum total of the demand of consumers for the given good, here a patented good in the examples we're using, and you can see it's downward sloping, which means that as price rises, less consumers will wish to purchase the good, and there'll be less quantity of the good provided by the firm. In a competitive equilibrium, I'm showing that here in the orange, the firm will price at a particular price and output a particular quantity. That price will be close to or right on, depending on the particulars of the market itself, the marginal cost of the good or service provided in a competitive market. A quantity will be produced, and then that revenue that goes back to the firm is in the orange shaded box there, the total revenue. Right? The important thing to understand about the way that patents work is that what we do is we call it a monopoly, and we'll talk about how it's not really a monopoly, but what you do is you give people market power or a monopoly power, and you give a firm the ability to raise prices without competition, and the optimal way of the optimal approach then tells a firm to raise a price to a particular level, and that level will then result in less quantity of the good or service being provided, but at a much higher price, and the net benefit to the firm increases over a competitive equilibrium, and sometimes increases dramatically. Right? The realities of the patent situation, of course, is slightly different because patents are not true economic monopolies in almost no circumstances. Right? A monopoly implies that there are not economically relevant substitutes, and in almost all cases in the patent context, there are economically relevant substitutes. If I have invented a particular pharmaceutical, which are often the closest to power to monopolies, it is still the case that there are almost always, although not necessarily all the time, but almost always alternatives that may, even if patented, offer a lower price, and so therefore I don't have true sort of monopoly power to price at whatever level I would choose. So instead, what we mean by patent pricing is that it's something above a fully competitive market, right? So the fact that you have a patent doesn't necessarily give you monopoly, but it certainly does give you pricing power, right? It gives you some ability to raise the price of your good or service above what you would be able to obtain for that price or good or service in a fully competitive market. And so I've designated that here in the purple, somewhere between a fully competitive equilibrium and a monopoly equilibrium, something like that, right? And again, the revenue would be in the purple box. That is more, of course, than a competitive revenue generation, but less than a full monopoly situation, somewhere in between, right? And obviously, each patent will have a quite different location along that demand curve, depending on the various circumstances. Most importantly, how big is the innovation? If the innovation is really substantial, then you might have more pricing power. If there are a lot of substitutes for your innovation, you're not going to have much pricing power, if any at all, and you'll be closer to competitive equilibrium. Better, broader inventions will be closer to the monopoly equilibrium. So the key thing to understand here is that this black area that I've shaded is what we describe as the deadweight loss. And what that represents is that when prices are raised above a competitive equilibrium, above the lowest they could possibly be and still be produced, then what you're getting is the reduction in numbers of people who purchase the good or service, right? So that means there are people who are foregoing that good or service because they either can't afford it or they don't value it highly enough or whatever. That's a social loss, right? That is a loss to society as a result of higher pricing, and therefore that's what we call deadweight loss, and that is one of the true costs of patents, is that by allowing patentees to price higher than marginal costs, you're going to suffer monopolization costs, otherwise known as deadweight loss costs. Less of the good will be produced, less of society will get to access the good. I mean, you can think about this in sort of a simple example. Let's say I am producing a drug for curing headaches, right? So if it's a fully competitive market, it isn't going to cost me very much it just doesn't cost very much to produce drugs, and I'm not going to be able to charge very much in a fully competitive market. It'll be pretty close to the costs of manufacturing, shipping, packaging, marketing, things like that. Basically all the costs that go into producing a unit of that product. If I have a patent, and that patent is for the use of the cure of headaches or something similar to that, then this is going to be quite different, and I'll be able to price, let's say, $100 per unit. Right? So you can see, instead of $1 per unit, for example, in a competitive market, if I was pricing at $100 per unit, what's going to happen? Well, there probably will still be people out there purchasing the good. It would be irrational for me to price it in a way that people didn't purchase the good. So whatever the price is that I choose, people are still going to buy it. The point here is that substantially fewer people are going to be buying it than they would at the fully competitive price, and it's that loss, those people who can't get access to the innovation that we're talking about when we talk about this deadweight loss cost. But I also want to emphasize here that this is not the only cost of patents, right? This is just one among a menu of various costs of the patent system. The monopolization costs are critical, but they're not the only thing. And in fact, a lot in the patent system tries to deal with these monopolization costs. And we'll go through a lot of these in this semester, but just to sort of throw this out there. So one question is, the first thing to ask about monopolization costs is how much of a problem are they really? I mean, if patents only provide fairly minimal market power, then you're not going to have a lot of deadweight loss associated with them, right? If instead you think that patents provide tremendous market power, then you're going to have a lot of deadweight loss. And so the first thing to note is we don't really know the magnitude of these monopolization costs. And in fact, they're going to be completely different for every single invention or innovation that's created. Second, one of the ways that we address this is by having a limited term for patents, right? And so what happens is that gives means that the costs, even if there are costs, are limited in their temporal scope, right? They end at some point. And having a limited term also encourages people to file early, to try and make inventions early and soon and file for patents soon, which means they expire earlier as well, which again means that costs that are borne are only borne for a fixed amount of time and not forever. The other thing that we do in the patent system to try and deal with this a little bit is we have doctrines that allow for differential types of scope depending on how significant your invention is. So very significant inventions, sometimes referred to in the literature as pioneer patents, will often have a broader scope through something called the doctrine of equivalence than other types of patents, more run-of-the-mill innovations that will have a narrower scope. So again, we think that in those cases, it might be more justified to give a broader reward. We also allow people to get improvement patents. We talked about this in class 2. We allow people to get new uses or improvements on earlier innovations, and it does not even have to be the patentee, him or herself, which means that almost immediately upon gaining a patent, many of your competitors will be attempting to improve upon your invention and thereby undercut your market position, thereby decrease monopolization costs, deadweight loss, and make society better off. This is, again, something that we want. We also have doctrines of patent misuse and antitrust to try and avoid sort of the worst types of behavior, the most egregious forms of pricing or the use of patents in ways that are intended to confer power that's not justified given the invention. And then indirectly, you could even view sort of the requirement that a patent be valid as an attempt to reduce monopolization costs. Again, making sure that the patents that we do grant are significant innovations are an important feature of the patent system and can help reduce some of these monopolization costs. Another important cost is rent seeking, right? What we refer to as rent seeking is efforts by firms or individuals given incentives to try and achieve economic rents, benefits, so to speak. So if you give people incentives to invent things, then they will invent things, and there's nothing particularly complicated about that. The problem is, and the downside is, that firms and individuals may overdo it. They may spend too much time on trying to get resources to get patents. They may spend too much time doing certain kinds of inventive work, that kind of inventive work that's most likely to result in a marketable patent, for example, versus the kind of work that would more directly benefit society as a whole. These are costs, right? These are costs related to the patent system. The fact that we have this economic incentive to develop these inventions does have costs, important costs, which are going to be reflected in the system. So how do we deal with this? Well, I mean, one thing that we do is we try and avoid duplication of effort, right? One of the costs of rent seeking is if a lot of people are racing at the same time for the same prize, for the cure for the common cold, there's going to be a lot of people duplicating effort, and that's socially wasteful. And so this publication process that we use in order to get a patent can help reduce duplication, right? You want to know what other people are doing with respect to investigating the cure for the common cold? Look at the patent office, look at the published applications, look at the patents that have been granted, see what people are doing. Right? The other thing that the patent system tries to do to deal with this is by having a hurdle, a relatively high hurdle called the non-obvious requirement that you have to get over in order to get a patent, right? So this forces people to not merely spend their time and money on simple, trivial type inventions, but instead spend their time and money on significant advances over existing technology, right? And so this can avoid sort of the detrimental rent seeking where people are simply trying to do trivial inventions, get a patent, get small amounts of money, and repeat. Instead, what we are trying to make them do is to invest significant amounts of money into research and development, make real advances, and work through it that way. And then finally, incentives favoring early applications mean that we try and pick winners as soon as possible in the patent system so that people don't race. If they do race, they don't race very long, and the winner of the race is relatively early, identified relatively early. And so those are the ways that we try and address rent seeking, but it is an important cost, right? Restriction of future innovation is an important aspect as well. And one question is, how do patents restrict future innovation? Well, What they do, in theory at least, is by granting a right to a patentee, that patentee can then determine how that invention gets used, including the use of that patent in new and unusual ways, the use of that invention in new and unusual ways, which could restrict innovation. Now, as we talked in Class 2, there are other incentives as well that might countermand this to some degree, which is people have an incentive to design around the patent and thereby create innovations that are distinct from the patent itself. But that's, how those trade off are hard to know. So how does a patent law try to deal with restricting future innovation? Well, you have to have a novel and non-obvious invention, right? You have to have a high hurdle. You have to get over the high hurdle in order to get your invention patented. So therefore, the idea is only a relatively small number of people are going to be able to do this and reap the rewards, and therefore there won't be as much restriction on future innovation. And the fact that you really have done something suggests that you are, in fact, the person who should be continuing to do this type of innovation. The use of claims to try and clearly delineate between what you own and what you don't own is an important feature of the patent system in this regard, which is if your competitors, if those who follow behind you are able to clearly understand what you do and don't own, then they can tailor their activities accordingly and avoid your patent. And then public disclosure helps this as well, because indeed, rather than restricting innovation, public disclosure can in fact enhance future innovation by providing new information to the public about what is the state of the art. Administrative costs are important. Administrative costs are those things we think of in terms of the cost of the patent system. The PTO, which is the picture on the right on the slide, is a massive undertaking and a very large administrative agency that would not exist but for the patent system, right? The federal court system, the Las Vegas Federal Courthouse is on the left there, is another example of costs. Obviously, the federal court system would still exist, even absent the patent system, but a significant amount of time is spent doing patent litigation, and enforcement costs are a very important feature of the patent system. And so I'm lumping here in the administrative cost category both the PTO sort of administrative agency costs and the administrative enforcement costs into this category, and both of these are costs of the system, right? So, again, this is obvious, but just to make it clear, the net benefits of any system, including the patent system, is just your gains minus your cost, right? And let's, look again at what our gains are, right? We think that by offering a patent system, we're going to get more innovation and invention, more public disclosure of new technology, more commercialization of the types of things that society wants more of, and more investment in invention, which is in the long run going to result in ever increasing rates and amounts of innovation. The costs, of course, are pretty important. Deadweight losses we've talked about, rent seeking we've talked about, possible restriction of future innovations, and administrative costs, right? And so how these two, the gains versus the costs, weigh out will determine the net benefits of the system. And the most important thing I want to get through to you here is consider how patent scope, or the patent power, you can also think of it in terms of the length of a patent, but just how significant the right that is granted by a patent relates to this is important, right? Because the broader a patent, let's go back and look at our list and think about a broader patent. Well, a broader patent is going to offer potentially much more gains, right? Because it's going to create more. If we give out broader patents, people are going to try harder. They're going to innovate more. They're going to disclose more, right? They're going to do more commercialization. They're going to do more investment in invention because the rewards of doing so are now greater. On the other hand, the costs are going to be higher, right? If it's a broader patent, you're going to get more deadweight losses for the reasons we talked about a minute ago. If there are people are going to race more, they're going to do more rent-seeking behavior and potentially bad rent-seeking behavior. The potential for restriction of future innovation is much higher with broader patents, and the administrative costs of both reviewing these sorts of patents and enforcing them will be higher. So if you have broader patents, you're going to have both higher gains but higher costs, and it's a trade-off at every stage, right? And this gets back essentially to the graph that we talked about a little bit in class 2, which is, there is a optimum point somewhere in the patent system where we've achieved an optimal level of patent strength, patent scope, and the problem is we don't know where it is, right? And the task of the patent system, the task of the law of patents, is to try and keep the system as close to the top of that curve as we can, right? And not allow us to slide down towards patents that are so weak that they offer very little benefit to inventors and therefore have very little gains, versus patents that are too strong and offer and have way too many costs for the gains that society gets from them. And so that, again, is sort of the Goldilocks principle. We want to be just right, just strong enough to get maximum social benefit without incurring too many costs. So the second thing that we're going to talk about, and this is going to consume our class time, is alternatives to the patent system. And I offer here a range of alternatives that we'll discuss, right? So one, and the most basic, is nothing. Let's do nothing at all. Variation on that is nothing in trade secrecy. Let's abolish the patent system or not have it at all. And if you want to protect your new innovations, you can go to the trade secret route. Keep your stuff secret as best you can, and so on, right? The other major alternative that's talked about a lot are advanced contracts for research. These are otherwise known as government grants. Obviously, we do a lot of this already. The NIH and the NSF are major agencies of the federal government that hand out millions and millions, billions actually, of dollars every year to research projects all over the country, primarily in universities, but not exclusively to universities. They fund private enterprise as well. These are advanced contracts. You apply for them. You say, I'm planning to do X, Y, and Z. I expect my results to be, A, B, and C. Give me money. And an administrator, usually an expert panel, will evaluate the various proposals, select the ones that are viewed as most promising, and fund them to the degree that they can, right? And so that's the concept of the advanced contract approach for research. And as I said, it works pretty well, and it works pretty well in particular kinds of areas too, which we'll talk about a little bit. So prizes for research are another possibility, another alternative to the patent system, right? In this, instead of paying people up front to do research, what you would do is you would pay them on the back end, right? You'd give them a grant, right? You'd say, oh, wow, you just cured cancer. Here's a prize, right? And this is, again, these things have been around for a long time. You do see some of these out there. You increasingly, interestingly, are actually seeing this type of mechanism in the private sector. One well-known example was a year or so ago, Netflix, the online movie provider, offered a prize, a very significant prize, $1 million, I believe, for anyone who could come up with a matching algorithm, a preference matching algorithm that outperformed Netflix's internal matching algorithm by 10% or more. And so that's an interesting approach. There are also other types of more aspirational prizes, like the X Prize for space exploration, or prizes for voyaging around the world nonstop in an airplane. Things like that are known, not really used as a part of government policy at this point. Every now and again you see a little bit of that, but not as a systematic approach. But people have suggested that this could actually be an important way of implementing an alternative to the patent system. So I had you read a few articles here, and I want to preface your review of these articles by saying I gave you full articles, well, except for the Abramowitz article, which was hundreds of pages long. I gave you only the intro to that. Some of these articles are fairly in-depth economic modeling, especially the Wright article. Don't worry at all if you can't figure out the economic models. That's not part of what we're doing here. What I do want you to do is try and figure out what he's saying and understand. And so for each of these papers, I'm going to offer to you a few things that I hope that you find out, that you consider as you're working through them. And so for Wright, what he's talking about is comparing basically three regimes: patents versus contracts versus prizes, right? And this is from an economic theory perspective. He has a few important things that I'd like you to take away from that. One is, what is the common pool problem? What does he mean when he says the common pool problem? What does it do? What's the impact? And does he have any suggestions for how to resolve the common pool problem? He also concludes that contracts are best unless there is private information, that is, information held by various individuals, distributed individuals, that is not known by anybody else. Why? So first of all, why does he think contracts are always best unless there is private information? And then why does he think and then what is it about private information that causes patents and prizes to be dominant over contracts? And then how does he suggest that we choose between the three options? I mean, what are the parameters of his solution, his results? He has a graph which offers some examples of that, and sort of sorting through his results on that graph is a useful exercise, I think. And then, assuming contracts are worst, then what's the trade-off that he finds for patents versus prizes, right? How do we choose between those two systems, and what is it that's different about patents and prizes versus contracts, right? So those are the things I'd like you to get out of the Wright paper when you're reading. And again, don't get hung up in the math and economic modeling techniques. Try and read past that and focus on his results and his arguments, interpreting his results. So Abramowitz has a paper that I gave you the intro to called Perfecting Patent Prizes. And basically what he's arguing is that there's a way of making patent prizes work, a way of overcoming many, if not all, of the shortcomings of patent prizes that have been noted by lots of other authors and commentators. And so a few things I want you to think about when you're reading that piece. One is, what is the patent prize in his analysis? What does he mean by patent prize? This is slightly different than a regular prize, but it has a lot of the same characteristics. What are the downsides? So he introduces prizes by noting some important theoretical downsides to their use, and understanding what that is, I think, is important. And then what does he propose? How does he think it's going to work? He ends up thinking that a patent prize system actually could work pretty well, given his proposed solution. What is that proposed solution is something that I'd like you to figure out. So Boldrin and Levine, The Case Against Patents, is an interesting article, and I will give you a hint from the outset. These two do not like patents, and this is probably the most significant, most important sort of and consistent set of anti-patent authors that are out there. They've done a series of articles questioning the value of patents, whether they work at all. They had one that was offering alternatives in the pharmaceutical industry that was interesting, and they get a lot of discussion and attention. They're smart and have interesting things to say, and so I'll be interested to hear what you think about this piece. So they marshal a lot of evidence in this paper that they say shows that patents don't work, and consider whether you find that convincing and whether there are alternative evidence or arguments that might be out there that would refute some of their case. And are they right? They have a nice part of their paper here is about the political economy of patents. Why do we have the patent system that we have? Why does it seem so difficult to get this fixed? And a question that to ask yourself as you're reading that piece is, are patents different? Is this different than any other area of government regulation, all of which has political economy issues, of course? And then finally, try and figure out if they have any, and if so, what suggestions they have for what to do. Is their suggestion truly to simply abolish the patent system and other intellectual property regimes, or do they have something more specific to suggest as part of their set of proposals? So again, it's an interesting piece. It is certainly not something you would read in most patent classes, but I think it's important to understand that there are significant thinkers out there who really question the value of the patent system and offer real evidence that there are serious concerns and serious things to think about.